Welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall.
Hello and welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall. My name is Kevin Rosenquist, and today's episode is Life Choices, the distinction between DNR orders and living wills. John, welcome back.
Nice to be back.
Can you explain what a DNR or Do Not Resuscitate order is and how it differs fundamentally from a will?
So basically a DNR is exactly what it sounds like. Do not resuscitate. If my heart stops, if I stop breathing, let me go. It is not fact dependent beyond the fact that I have ceased to breathe. I have ceased to have a heartbeat. And that's the end of it. The problem is, and this is, I really attribute a lot of this to the media, and especially bad television. And by bad television, I mean any legal show out there, namely Suits and stuff like that. It's
not even Law and Order. I thought that was completely factual.
The closest I've ever come to enjoying a legal show is Boston Legal, and it was purely for the sarcasm.
I agree. I liked that show too, and it was purely for James Spader. Yeah, and his sarcasm.
And William Shatner.
And William Shatner. Right. Yeah.
There, and that's it. Beyond that, no good legal shows.
Yeah.
And the problem is the term living will and DNR are thrown around, and people really don't understand what they mean. And what I find in most of my conversations with people, when they say DNR, what they actually mean is a living will. They don't understand the differences. And then sometimes when they say living will, what they actually are talking about is a designation of healthcare surrogate. So here's the difference between the three. A designation of healthcare surrogate says, if I'm incapacitated, here are the people who can make my healthcare decisions for me. Plain and simple. And it could be temporary, could be permanent. You have a car accident, you have a concussion, you're at the hospital, you don't know what day it is, much less that you were in a car accident, but they need somebody who can make decisions for you. That's your agent or surrogate under the healthcare surrogate. The living will is where you're saying, hey, I'm terminal, or I have an end-stage condition and I am permanently mentally incompetent. Do you or don't you want to be kept alive under those circumstances? A DNR is simply don't resuscitate. And I always tell people, I personally have a living will. If I am completely mentally incompetent and let's say I'm on a machine that's keeping me alive, but that's how I'm going to live the rest of my life and I'm not going to be competent. Take me off of life support. Now, if I'm competent, it's my choice if I say, yeah, I want to continue fighting. And quite frankly, when I think of Stephen Hawking, when I think of Christopher Reeve, both of those men went through incredibly difficult situations in their lives, and yet they persevered. And their contributions to our society are tremendous. I mean, from a scientific and also just the Christopher Reeves Foundation raises tens of millions of dollars every year for spinal cord research. And those two men took a personal tragedy and turned it into something that benefited us all. But imagine becoming completely mentally incompetent. I personally don't want to be kept alive in that circumstance. Right. But again, I don't have a DNR. Now, if I get diagnosed with stage 4 cancer and they go, John, you're terminal, you've got 6 months to live, I'll probably sign a DNR because you know what? If I stop breathing or if my heart stops, don't resuscitate me because the cancer is still going to kill me. Right. Okay. So I always tell people you have to look at the facts and circumstances and understand what the documents mean and when they apply as to whether or not you have it signed now or either sign it in the future or empower a surrogate under a healthcare surrogate to sign it for you in the future.
So you mentioned the, what was the other one? That was the DHCS?
A designation of healthcare surrogate is what we call it in Florida. In other states, they'll call it a medical power of attorney.
Medical power of attorney. Okay. I've heard that one before. Okay. Mm-hmm. That makes sense. And do you need to have, do you think it's important to have a DNR and a living will and the DHCS? Are all of them necessary?
So I recommend 3 documents that people carry. Like I said, 4, 3. Okay. Designation of healthcare surrogate. If I can't make my own healthcare decisions, here are the people who can make them for me.
Okay. Living
will. Again, that's more of an optional one. If you are permanently mentally incompetent and being kept alive on a machine or, some type of treatment can extend your life, but it won't cure you, do you want to be kept alive or take you off medication, take you off the machine, let you die naturally? The third is a HIPAA waiver. And that is purely a waiver of your medical privacy. And what it says is, here are the people who can access my healthcare information. And that HIPAA waiver applies to every doctor, hospital, pharmacy, insurance company across the board. The DNR is very dangerous to just walk around with. And let me give you an example why. So I did an estate plan for a lady in her late 70s. We did her living will. We did her HIPAA waiver, healthcare surrogate. I explained all those different documents. And the family said, well, are you going to do a DNR? And I said to the client, I said, are you terminal? She goes, no, I'm not terminal. I said, so you're not like dying? She goes, well, I'm taking medications. I have high blood pressure, whatever, but no, I'm not dying. I said, well, then why would you do a DNR? Because if you had a heart attack and they could resuscitate you and you have another 10, 15, 20 years with your family, would you want it? Oh, absolutely. I said, okay, we won't do a DNR. But a year and a half later, the family calls me and says, she's died, the client's died, and we need to talk to an attorney about a medical malpractice suit. I said, well, what happened? They said, well, she was in an ambulance. They didn't try to help her. She died on the way to the hospital. The hospital didn't do anything to revive her, and we think that they're just covering up malpractice and we want to sue. And I said, okay, I need more than just that. Tell me more. They said, well, she was choking. It was Christmas dinner. She was, eating, started choking. We called the paramedics and she was having a hard time breathing. Paramedics show up. We give them the HIPAA waiver, the healthcare surrogate, the living will, and DNR. I said, well, wait a minute. You had a DNR. We didn't do one. Well, we talked about it as a family and she thought it was really important to have it in case she got cancer or something like that. I said, okay. And they said, well, on the way to the hospital, she stopped breathing. Paramedics logged it, didn't try to revive her. And I said, okay. And they said, well, we want to sue. And I stopped and I said, for what? They didn't try to revive her. I said, she had a DNR. And they said, yeah, but she didn't die of cancer or anything. This was choking. I said, yeah, she had DNR. I said, I'll tell you what, let me get my friend who does medical malpractice claims. Let's get him on the phone and let's talk to him. First question out of his mouth after that was, she had a DNR, right? And they go, yeah, you have no case. Mm-hmm. They are not required to resuscitate her. That's what it means. And the family said, but that's not what was intended. She didn't want to be kept alive on a machine. She didn't want to be kept alive if, resuscitated if she had cancer. And I said, that's the living will. The problem is you guys were so insistent on that DNR that you did it anyway. And it's blanket across the board. It's not dependent on having some type of illness or anything. And, and then they were like, well, but they could have ignored it. And that is true. Paramedics and ER docs and triage are allowed to ignore a DNR, but they're not required to ignore a DNR. And oftentimes, many of them will honor it because they're more afraid of the lawsuits for violating the DNR than they are a lawsuit for following a DNR. And so, that's where I tell people you got to be very careful with it. My father-in-law was 94. He was in the hospital. He was getting some treatment. And, he was having a reaction to some things and was having some mental issues at the time. And the doctor asked my wife, well, where's his DNR? And she goes, why does he need a DNR? Oh, he's 94. He can't have a good quality of life. And she's like, that's really not your call because he's happy. He's got his family. We're with him all the time. He watches golf and he talks to us all the time. Why would you make that comment? And that's kind of the issue is sometimes I find the people pushing the DNRs are the people that are saying, well, you couldn't possibly have the same quality of life that I do. Mm-hmm. And therefore you should have it. And it's like, no, it's really your decision to make. Right. And it shouldn't be something that others talk you into. And you should understand the difference between a DNR and a living will, because I'm finding that too many people just confuse the two and don't realize that the DNR is very sweeping and very, very controlling in those situations. And its use can very well backfire.
I mean, it's right there in the name, right? I'm surprised that people are having such a hard time understanding that because I'm not going to claim to know the ins and outs of all of these documents, but do not resuscitate means to me, hey, if my heart stops beating, don't do anything.
It's such I want to say dangerous document because it is if it's misused, okay, or if you're just carrying it around. I mean, I had a guy, he just carries one in his pocket, and he said,
what?
Well, this way, they don't resuscitate me if I'm not going to have a good quality of life. And I'm like, but who's making that decision? The doctor? The paramedic? They don't know you. How can they determine your quality of life? And he kind of looked at me, he's like, well, I never thought of it that way. And I'm like, well, that's the problem. But, in Florida, for a DNR to be valid, it has to be printed on yellow paper. I mean, That's the only document I can think of that requires a very specific color. And what that is, that's the state going, yellow, caution. This is a dangerous document. It's an important document, but you have to understand its use. And hey, I'm not, in any danger of dying here right now, tomorrow. My health isn't bad, but I also know I could be in better shape. Looking at myself on the camera, and I realize I need a haircut and I got to lose more weight. So if you're thinking that at home, you're not wrong. But again, that's a thing I need to address, but I wouldn't carry a DNR around like that, because if I had a heart attack and they resuscitate me, who's to say I don't have another 30, 40, in this day and age, 50 years left. And that's a lot of time that I get to spend with my wife and my family and, so forth. So again, I want to be very cautious with the documents I execute and present to medical providers.
Obviously, most people don't carry the DNR or their medical documents around in their pockets, like the one your one friend or client did. What should individuals do to ensure that the DNR orders or the living will are recognized and honored, especially if it's an emergency situation?
So in our office, we have implemented two different strategies. One, the client management software that I use has a client portal built into it. So just like when you go to the doctor, doctors have your client portal. You can send messages and all that stuff. Well, we have the same thing. And so what happens is we'll ask clients, do you want your healthcare surrogate to have this information? Well, yeah. And we say, don't email it. Don't pop a copy in the mail because you don't know who's going to get it. Let's give them access to the client portal. And in our client portal, the client can choose as whether or not they want them to see all their documents or just specific, sets of documents, like the healthcare documents or the power of attorney or the trust and will package. So again, they can pick what people see. But I had a gentleman in my office this week. We live in Central Florida. His daughter lives in Washington State. So, again, all the way across the country.
Almost hard to be farther.
Exactly.
Yeah.
And yet we can activate that portal and she has instantaneous access to it and access on her smartphone, laptop, computer, iPad. So if she's at the hospital, she can pull it right up. The second thing that we have implemented is a program through a company called Legal Directives. And here. So I have my Legal Directives card on me and I carry it behind my driver's license. And it has a PIN number, it has a client number, and you go to the website on the back, and my healthcare surrogate, my living will, and my HIPAA waiver are immediately available. I can even identify if I'm taking any medications. I can also identify any medical conditions I have. So if I'm allergic to morphine, which I'm not, morphine's kind of good if you're in the hospital, but if I'm allergic to morphine, I can mark morphine allergic so they don't give it to me.
Right.
And when you're in an ambulance, those ambulances have computers in them. It's all networked. And that's one of the few benefits to Obamacare. That's probably the only benefit. It's a totally different issue, but is the networking of systems. So again, when you have something like that, they can access it. They have instantaneous access to your healthcare surrogate, living will, HIPAA waiver. That HIPAA waiver is important because if you say, hey, my daughter, my son, whomever can make my healthcare decisions, that HIPAA waiver is what says, give them the information they need so that they can make an informed decision. So, again, it's important to have the ability to share these things. And in a modern era like this, there are many ways to do it outside of paper copies or email, both of which I think present a little bit of a danger in other people that we don't want having access to it, getting access to it.
What kind of advice do you give to people when they're trying to consider what they want, whether it's a DNR, whether it's a living will or the DHCS? What kind of questions should they be asking themselves, each other? What kind of conversations should they be having as a family?
So we'll start with the HIPAA waiver. Who do you want to have access to your healthcare information? And it can actually be more than just the people making your healthcare decisions. I have a kind of a niche area that I do planning for families that have special needs children. So if I'm doing something for the parents and they're going, yeah, my special needs son or daughter, they can't be decision makers. We'll still include them in the HIPAA waiver. So, if they're in the room, you're in the hospital, we don't have to say we need, Jimmy to step out of the room so that we can have a conversation here because what we're going to talk about is covered by HIPAA. All right. If you're competent, you can waive HIPAA, but you're incompetent, you're in bed. We need that written down. Okay. So we'll ask questions. Who do you want to have access? Is there someone you want to have access, even though they're not going to be a decision maker? For the healthcare surrogate, who do you want to be a decision maker? And you got to, again, this kind of goes back to a conversation we had before about power of attorney. Who's going to be your agent under the power of attorney? Well, same thing with your healthcare surrogate. Who are you going to name? I'm a cold-blooded, heartless attorney. Okay. Not really, but let's be honest.
I saw that on your website, and I think it's in your email signature. Yeah.
But I have no medical training. Whereas my brother-in-law is a fire chief for a town up in Ohio, Granville, Ohio, and shout out to Casey Curtis. But he's got medical training because of his role as a paramedic. Sure. So if my parents are like, look, John, we've named Casey because he's got the medical training. Honestly, I can't be offended. Because that's not my skill set. So again, look at your family. Do you have a nurse, a doctor? Do you have someone with medical training who understands the lingo, who understands what they're going to be talking to the doctor about? Who, like my wife, my wife is amazing at this. She hears something, a diagnosis or whatever, and she's going online and she's reading everything. What can I find out? What do I need to know? And then she's coming into doctor's appointments and she's asking doctors about, well, what about this treatment? What about this treatment? And she's not going to just WebMD. She's on the CDC's website and she's on the state, Florida Board of Medicine's website, and she's researching all these things. Those are the people that you say, look, I really want them as my surrogate because, they're going to look out for me. Do we want somebody though, who's just a pushover who the doctor goes, well, here's what we think we should do. Or the worse, the insurance company goes, well, here's what we think we should do. Are they going to fight for you? Or are they just going to go, okay, Yeah. Again, that's where we need somebody who's going to be an advocate. And you want to ask those questions and you have to do some soul searching on that. Look, your kid can be the best kid in the world, but maybe that's not their strong suit. That's okay to say, I chose somebody else because you know what? This is an advocate for me. And they can decide for themselves what they want to do with their life, but I need someone who's going to be my advocate. And then the other thing they need to do is take the time to listen and talk to an attorney who's going to explain the difference between the documents. One of the things that I avoid in my practice and something I tell people they should avoid with any attorney or any professional they talk to is somebody going, well, here's the documents you need. That's not an answer. You need to know what you're signing and why, the importance of it. It's interplay with your life plan. An estate plan should complement your life, your medical decisions, your financial decisions, where you want to live, what you want to do, your hopes, your dreams, how it impacts your family. Those should be conversations undertaken as part of an estate plan. You can't look past those. And what you really need to avoid is someone just going, well, here's what you need, trust me. You know what? Trust is great, but let them explain to you why and earn that trust through knowledge and conversation. Mm-hmm. So those are really the keys there to having good documents. And that applies to the healthcare surrogate, power of attorney, trust, will, anything, but especially with medical decisions.
Like those are important questions to ask and great tips for sure. Well, thanks for tuning in to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall. To connect with John and the team, head to marshallawpa.com. And don't forget to like our videos and subscribe to our channel. John, great seeing you again. Thanks so much for the conversation. Really appreciate your time.
Great seeing you. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.